All right, so Oana-Maria Stefanescu is a doctoral candidate and research assistant at McGill University. And your presentation title for today is On Treating Like Cases Alike and the Circulation of Legal Reasoning Among National and International Adjudicative, wow, you might have to help me there next time, bodies. And the second part is Reinterpreting the Practice of Cross-Jurisdictional Referencing. So Oana-Maria is a doctoral candidate and a research assistant in Montreal, Canada, and her dissertation explores cross-citation practices among national and international courts and tribunals, aiming to deconstruct and reinterpret common dogmas about adjudication. Oana obtained a LLM from the same institution with a focus on international investment arbitration, and completed the ICC summer course in international commercial arbitration. And she also holds a BCL degree from West University of Timisoara from Romania. Her research interests include legal theory, tech law, and the rights and culture of ethnic minorities in the Balkan region. Oana-Maria is the recipient of several fellowships and awards, and I'm going to name all of them, such as the Aubrey Senes Fellowship in Law, the Yves Fortier International Arbitration Graduate Award, and the Graduate Excellence Awards. In the past, she has acted as senior and executive editor at the McGill Journal of Dispute Resolution. Thank you very much for joining us today, and I'm looking forward to your presentation.
First of all, hello everybody. Thank you, Danny, for this introduction, and thank you both, Ido as well, for putting together this event. Before anything else, I just wanted to note that I think I'm very fortunate that my presentation follows Alma's, because the practice that I am studying challenges this idea that law is state-bound or system-bound more generally. And this is what the term cross-jurisdictional in the title actually refers to in relation to the practice when a court or a tribunal from one legal system uses a case in its decision-making process that originates from a different legal system. So to start off, I thought that instead of breaking down the legal concepts that are at the core of my research, it would be more useful for today to present the thought process that led to this project, because my initial fascination with the practice actually came from a lack of knowledge at the time when I was still a law student. And I think that for better or for worse, it continues to be my driving force today. And the reason why I say this is because in time, legal education and professional experience shape the way we think about law, about legal actors, as Ronan also pointed out earlier. And sometimes we end up forming biased views, which of course influence the type of questions that we ask. So for example, when at the beginning of my law degree, when I found out that the Romanian civil code reproduces to a great extent the Quebec civil code, which is actually quite common, I asked, perhaps a little too naively, some of my peers and authorities if they thought that Romanian judges could use decisions that interpret these provisions, but that were made by other courts, not by the Romanian judiciary. And the majority of the responses that I received was that they could, but why would they? Why would they not use their own case law? And this type of reaction illustrates what essentially is the dominant way of viewing the practice to cross-jurisdictional reference. That is as a kind of departure from the accepted practice, as a kind of exception from the norm. And the instinct when dealing with exceptions or departures is to try to figure out what causes them. This type of approach is the main approach adopted in the literature that addresses the topic. In my research, because I like making use of visual representations for my arguments, I call this dominant way of analyzing the practice the top-down perspective. So imagine a world divided into compartments that the legal community calls systems. And each of these has their own legal, social, cultural particularities. So when a decision from one compartment makes its way into another compartment, that decision is labeled as an external or a foreign decision. By contrast, I think that if we change the starting point of the discussion and we shift the perspective to a bottom-up account, meaning a perspective that focuses on the decision and on the decision-making process instead of the compartments that label these decisions as external, I think that we might be in a better position to see that the practice actually tells us something important about adjudication in general, about the practice of adjudication. And it's not, these instances are not merely isolated phenomena. For example, what it tells us is that adjudication is not a confined practice. It is a global practice of law, that it plays a role as a mechanism of governance, meaning that it plays a role in the formation and in the transformation of laws, both locally and internationally. And I think that what is extraordinary about this, from my perspective, is that this happens on a case-by-case basis, unlike legislative acts. But before I go into more detail with that, instead of picturing this world map of divided systems, I want to turn the attention to the courts and the tribunals that engage in this practice. And the way I like to imagine this is like almost like a web of interconnected nodes that are in a continuous process of engagement. This practice happens at a domestic level, particularly between constitutional courts. It happens between international courts. It happens between national and international courts, so basically at all levels. And in some cases, it even happens when there is no obvious connection between the adjudicative bodies, the courts or tribunals, or their legal systems, as would have been the case with the Romanian and the Quebec civil codes, for example. So what this tells us is that the compartments, or the borders making up these compartments, are not as fixed as we thought or as we like to think. Because even though they set in a way the limits within which a decision must be made, they're also subject to the interpretation of the adjudicators. In legal discourse, we define these limits through concepts such as authority, legitimacy, precedent, the rule of law. And insofar as these concepts are concerned, they're quite difficult to translate into common language. And to be honest, I was very hesitant about bringing them up today. But if there's something worth noting about them, I think it is the fact that even though we attribute such great importance to them, we use them almost like lenses through which we make our analysis about the practice and about law. There are actually diverging understandings about these concepts, and these diverging understandings about the concept create a gap between what we think we know about the practice and what might be actually happening at the front lines. A second aspect I think it is worth noting in this regard is that not only is this practice happening despite these limits, but it's been happening long before they were put in place with the emergence of the nation state, as Alma noted. Cross-jurisdictional referencing has become a fashionable topic in the past decade, and it's certainly facilitated by globalization, but it is not a new practice. In fact, it's one of the means or a vehicle through which lines of reasoning about how a situation should be resolved have been traveling and have been changing, and with time and acceptance have taken the shape of what we call rules, principles, or laws that govern our conduct. A good example, and something that I want to note, a good example of this, I think, is the principle of proportionality, which is present in most modern constitutions, although not with the same meaning, but adapted to that constitutional reality. And in any case, all of this, I think, is a good reminder of the fact that there is both great responsibility as well as opportunity in the act of adjudication. And these are the my main takeaways for today and the little time that I have left. The responsibility comes from the understanding that what I decide here as an adjudicator, as a judge or as an arbitrator, may have an impact elsewhere, whether that elsewhere is within my own system or in a different legal system. And it might have an impact not only on how another case is being decided, but it might also form expectations and determine changes in the law. The opportunity, on the other hand, concerns opening up the decision-making process to external sources. Now, adjudicators routinely use past decisions in all sorts of ways to distinguish between cases, to support their own arguments, to draw analogies. The important aspect to remember is that the purpose of a past decision is to help make a better decision in the case at hand. And in my opinion, the situation is no different whether we're talking about internal cases or about external cases. Then to turn back to the example that I mentioned earlier, if a decision made by a Quebec court could prove useful to Romanian judges, the question to ask is not why would the Romanian judges make such a choice, but what are the distinctions or similarities in fact and in law between the two situations. And with this, I conclude a very brief overview of my project, and thank you for your attention. Of course, if anyone wants to discuss further, I'm more than happy to do so.